The Supreme Court of the United States has agreed to hear a historic and potentially transformative case challenging an executive order issued by President Donald J. Trump that seeks to end automatic birthright citizenship for children born in the United States of parents who are undocumented immigrants or only temporarily in the country. The case raises fundamental questions about the scope of the 14th Amendment, the meaning of the Citizenship Clause, and the powers of the executive branch over U.S. citizenship. The executive order, signed on January 20th, 2025, asserts that children born to parents who are neither U.S. citizens nor lawful permanent residents should not automatically be granted citizenship at birth because they are not fully subject to the jurisdiction of the United States. Historically, the 14th Amendment has been understood to guarantee that almost everyone born on U.S. soil acquires citizenship, regardless of parental immigration status, with very limited exceptions, such as children of foreign diplomats. The Trump administration's policy represents a direct challenge to this century-old understanding of constitutional law. Immediately following the issuance of the order, several federal courts blocked its implementation. Judges repeatedly ruled that the order likely violated the Citizenship Clause of the 14th Amendment, citing long-standing precedent including the landmark 1898 Supreme Court decision in United States v. Wong Kim Ark, which affirmed birthright citizenship for children born in the United States to immigrant parents. Some courts issued nationwide injunctions, effectively preventing the order from being enforced anywhere in the country, while others limited protections to the parties directly involved in the lawsuits. Earlier this year, the Supreme Court addressed a related procedural issue, ruling that lower courts cannot issue broad nationwide injunctions to block federal policies for everyone affected, but must instead limit their rulings to the parties before them. While this narrowed the scope of lower court orders, it did not resolve the central constitutional question, whether the executive order restricting birthright citizenship itself is legal under the Constitution. By granting certiorari, the Supreme Court will now directly confront that question, placing the fate of birthright citizenship for potentially hundreds of thousands of U.S.-born children at stake. Legal experts warn that if the court upholds the executive order, it would fundamentally change the landscape of American citizenship law, potentially creating a two-tiered system in which some children born on U.S. soil are denied citizenship based on their parents' immigration status. This could have wide-ranging implications, including legal and social uncertainty for affected families, challenges to civil rights protections, and a redefinition of the meaning of belonging in the United States. On the other hand, a ruling striking down the executive order would reaffirm the traditional understanding of the 14th Amendment, maintaining that birthright citizenship applies broadly to nearly all children born in the United States. Such a decision would preserve over a century of constitutional precedent and signal that the rights conferred by the 14th Amendment remain robust, regardless of shifts in political priorities. The Supreme Court is expected to hear oral arguments in spring 2026, with a final decision likely by summer. Whatever the outcome, the ruling will have profound and lasting effects on immigration policy, citizenship law, and the interpretation of constitutional rights in the United States. The case is widely seen as one of the most consequential for the country's legal and social framework in decades, potentially shaping debates about immigration, citizenship, and equality under the law for generations. This case also raises broader questions about the balance of power between the executive branch and the judiciary. By challenging an executive order in court, plaintiffs are asserting the judiciary's role in upholding constitutional protections against executive overreach. The Supreme Court decision will not only address the narrow question of birthright citizenship, but may also set precedents for how far a president can go in unilaterally redefining constitutional rights and altering long-standing legal interpretations. As the nation awaits a court's ruling, the debate over birthright citizenship has become a flashpoint in the broader national conversation about immigration, identity, and the meaning of citizenship in the 21st century. Families, lawmakers, and legal scholars are watching closely, understanding that the Supreme Court's decision will reverberate far beyond the courtroom, influencing the rights of countless individuals and the principles underpinning American democracy. The upcoming Supreme Court decision represents a defining moment for U.S. constitutional law. Its outcome will either affirm the century-old principles of birthright citizenship or redefine them in a way that could alter the nation's understanding of who qualifies as an American citizen from the moment of birth. This case is poised to leave a permanent mark on the legal, social, and political fabric of the United States, making it one of the most closely watched and consequential cases in recent history.